Mark, after lawyering assiduously for Fairfax for 20 years, what do you regard as the biggest change in that time?
Oh, the departure of David Hunt from the defamation list, that wonderfully patrician manner on the bench, all of that learning, not to say that abstruse technicality and his fondness for correcting the Court of Appeal. Approach has changed a lot. Doing away with juries, getting juries back again, under the new Act, enormous changes when we went through the 7A period. No win, no fee, and the reluctance of courts coupled with that to order security for costs means over the last 5 or 6 years, extraordinary number of bankrupt and indigent plaintiffs suing, losing, and then proving to have no funds from which to make good the award of costs. And if one thing needs to be changed, that's the thing at the moment.
Do you think media defendants have become less willing to defend what they publish these days, or is it just a plaintiff's world?
Oh, not at all. It's not a plaintiff's world any more than it ever was. The cards are still stacked very heavily in the plaintiff's favour because of the presumption of falsity.
Mark, what would you say was the most important case you ran in your time with Fairfax, and why?
That's very hard. Perhaps Fairfax and the local court, because it dealt with and deals with the right of media interests to be heard in answer to suppression orders, which are a terrible threat to the open administration of justice as well as to press reporting. There have been a lot of very interesting cases, but I think that's probably the most important one. The defamation cases come and they go, but they tend to turn pretty much on their own facts. And truly, the really interesting ones I was involved in were less in my time working in-house at Fairfax than back in the old days with Graham Bates and Ian Angus at Mallison. We did some wonderful cases, including the third Morgan trial. Definitely Fairfax and local court. Yeah.
What do you see as the strengths and weaknesses of the new Defamation Act of 2005?
There are some terrible problems around the defence of comment. It is a great missed opportunity that the word imputations has been used again. There are big problems with the defence of contextual truth, particularly because you can't plead back meanings anymore. Certainly doing away with the public interest element in New South Wales and doing something, although it had already been done in New South Wales, about the right of corporations, big corporates, to sue is all good. Having a look at what the ALRC is now saying about privacy and a privacy tort, there is a real risk that particular gain, that is the public interest element gain and the no de facto privacy issue in New South Wales and defence of truth, risk being overturned. I think that's the best thing from the media perspective. People will say offers of apology and a means of resolving matters more quickly and efficiently. I have yet to be convinced that offers of amends actually do anything very much. Let's hope they work, but I haven't seen any evidence of it so far. Possibly getting rid of 7A trials, certainly ensuring that a jury will hear the defences are very good moves.
And as far as advice that you would give your successors, Mark O'Brien and company at Fairfax, printable advice, what would you say?
Oh, advice is a very dangerous thing to give, Yvonne. And,
you've been giving it for 20 years.
I've been giving it for 20 years, but not to Mark O'Brien. I think I'll have to pass on that question. I truly do. You can never advise other lawyers. They might sue you for professional negligence apart from anything else. And I'm sure that they're old enough and ugly enough to look after themselves.
Mark, what's on the horizon for you?
Well, I'm going to the bar, as I think people probably know. I'm looking for the right birth, and that'll be in May next year. In between that, I've been asked to co-author a book with Mark Pearson from Bond University, another edition of his legal text, which I'm working on pretty hard. I'm going to see some more of my children, which will be wonderful. I'm on retainer to Fairfax, so I don't know what they are going to want out of me in the next 6 months or so. But I'm really looking forward to, much as it's been wonderful to legal stories on a day in, day out basis for 20 years. I'm looking forward actually maybe to learning a bit of law again, which will be good.